the time?
There was a New York Times reporter by the name of Molly Ivins, who was from Texas. She's the one who, with George W. Bush, called him shrub, and was the one that coined that phrase for him. So Molly Ivins was, I guess, very well known. She's passed away as well. But she wrote an article that was in the New York Times that said something about President Jimmy Carter has appointed a judge, and no other judge can make this statement as a convicted first-degree murderer living in his house. And she wrote this story. There was quite a bit of publicity about it.
I mean, his story is profound, and your experience with him is profound. We'll talk about sentencing practices more when we get into your judicial career. But I wonder whether you have any observations about how that experience sort of shaped your sentencing philosophy.
Well, yeah, and it shaped a lot of things with me. First of all, that case was badly handled from the very beginning, and the law at that time has changed. With an expert could now come into court, whether it's accepted or not by the scientific community, and say, I've done the research and this is what I say, and it could be brought forward. But in those days it couldn't. It had to be, in order to be admissible, it had to be considered to be orthodox doctrine. So that was bad at the time. And the other thing is that one of the things that I paid attention to is, and I think I got a lot of this from my conversations with Dr. Brant Steele, the psychoanalyst, but when people are dealing with what is objectively referred to as parenticide, that they have almost everyone has a deep-seated fear of this. It's related to the Oedipus complex, the Electra complex, and parenticide is one of these unspoken, deeply subconscious fears that people have. And they hear of a child killing a parent, and there's just horror attached to it. Well, if you pursue it and you understand why all of that is, the effect on my sentencing approach is it's consistent with my thought that you can't simply look at a statute and look at a report and put your thumb on it and say that's the sentence. You have to look at a sentence from every possible perspective, and that includes the victims and the fears that they might have, or what the victims may have done that unintentionally or intentionally has helped to create this terrible situation. You have to look at the defendant and the friends, the education, the health, physical and mental, of all of these people. And you have to look at society at large and see what's going on with the publicity that surrounds these things. The Bresnahan case was highly, highly publicized, and that did not help him. People would read it and say, oh, why aren't they executing him? Oh, you can't execute anybody under the age of 18. Well, then he should spend the rest of his life in prison. End of story. And it wasn't. It wasn't. End of story. And we didn't know so much about it. I learned a tremendous amount about the battered child syndrome and about the struggle that scientists had at that time, and I think still do to some extent, to get their findings and their theories that are advancing knowledge, and to get those things accepted. And it's very, very difficult. People are entrenched with notions, and parenticide is one of them. And it affects judges just as much as it does anybody else. So when you talk about it, there's an immediate response of, even if it isn't an identifiable response, there's a subconscious reaction to the idea of parenticide. And so that had a big effect on me. The other effect is that, it's a shame that one person with his intelligence and his drive and dedication was able to overcome tremendous brutality. He suffered psychological battering and physical battering as a child, to be driven to that point and then to come out of it and to dedicate his life. Rehabilitation is always a possibility. But the other thing you have to look at as a judge is to look and see the abject failure of our punitive prison system. Because what was he doing there in the first place? He shouldn't have been there, ever.
As a 15-year-old?
As a 15-year-old, he should never have been there. He should have been taken over to the state hospital. He should have received the therapy he needs in 1 or 2 years and been out. And I know that for a fact because I had another case with a 15-year-old boy that murdered a 9-year-old girl. And only this time he was found not guilty by reason of insanity. And he went to Pueblo, and that had something to do with my appointment as a judge too, because that particular case, it was called, the little girl that was killed was Paula Sue Steinbeck, and it became the Colorado Press Association's story of the year. So it was just, inundated with news everywhere. But we were able to get him, and that's when I was public defender, and we got him down to Pueblo, and he spent about a year there, and most of the time lived in the house of the superintendent of the hospital, and received some therapy, and got out, and went back home, and was able to build a life again. And so that kind of thing, I think, is what we need to look at, is what, I'll say one other thing and then I'll answer your question, but the idea, you hear all the time people saying, I want justice for somebody. I want justice for, whoever was killed. And they say, I want a prosecutor, I want justice for her. That's not justice, that's vengeance. Justice is balancing. That's what justice means, is to balance, to restore. And people are talking about they want justice all the time when they really mean they want revenge. They want a legitimate